Well, here we are. We've made it to the last of our 15 chapters that we'll have for our comprehensive final. So welcome again for the two sections of summer 2019 class. Be on the lookout now for some emails that will give you updates on how to prepare for the final. And we'll have that final available on Wednesday and Thursday of the last week of the semester. And again, that will cover chapters 1 through 15. So here we are with the last of those chapters, chapter 15, the Supreme Court. You'll see here on the very beginning of the chapter, and you have a couple of pages of introduction, gives an overall description of this institution, and you'll see here near the end of that description this reference about the Supreme Court and the use of the court system in general. The heavy use that Americans make of the courts is also an indication of the extent of conflict in American society. And given the existence of social conflict, it is far better that Americans seek to settle their differences through the courts than resort to violence or otherwise take matters into their own hands. So when you do see the references that we're a litigious society, that people sue one another and they don't get their way, or they seek some sort of physical injury or mental harm, and which can certainly be legitimate, that they would now seek the recourse through the courts. And while we may think that that's a burdensome path, and perhaps it is, what is a better alternative? And that's the way your textbook is setting this up, by saying we have an important aspect here when we look at the courts, that if we did not use or did not have this as, in a way, a release valve and a method of resolution, what would be used? And so there we can see the importance of the courts. The courts have had a continued impact on the shaping of our society and certainly the shaping of our laws. And there can be cases in which it seems to be perhaps not that important at the first glance, and then we can get some greater interpretation of the impact. But this example here that I'm sharing with you is one more example of how the courts can override or overturn elected bodies. In this case, they're overturning a decision, a law made by the California legislature. So when the California legislature had passed a law that would ban the sale of violent video games to anyone under the age of 18. The Supreme Court reasoned by a majority vote that it was a violation of the First Amendment to have a legislative branch make that decision. It was up to parents to make that decision whether a game was too violent for their children under the age of 18. Now, whether we feel one way or the other about that decision, I'm sharing that with you more than anything else to say this is the power of the courts. As long as other elected bodies go along with it, that you have the courts say, this is our interpretation of the First Amendment, this segment of the Constitution, and we overturn your actions in this case based on our judgment. So there you can see the power of the court. We've seen the power of the court in all kinds of cases throughout this semester. When it comes to ending legal segregation in public schools, Brown versus Board of Education, giving people the right to representation in the courtroom, despite not being able to pay for that representation, Gideon v. Wainwright, same-sex activities between consenting adults in privacy are to be protected, Lawrence v. Texas. People have the right to purchase a handgun within the city of Chicago, and that then consequently leads to an interpretation that the right to bear arms means the right to purchase a handgun, McDonald v. Chicago, the Second Amendment, Brown versus Entertainment Merchants Association, dealing with the First Amendment, that's First Amendment expression, to have parents make the decisions whether or not a young person, a child under the age of 18, can buy a violent video game. United States v. Jones, determining the length of time that a GPS can be placed on a car without an additional search warrant. Again, you're dealing with the Fourth Amendment. So we see in these cases that we're covering here, Fourth Amendment, Ninth Amendment, Second Amendment, First Amendment, 14th Amendment comes into play in every one of these cases. But these cases are clearly shaping our society and changing our laws. And we saw in the year 2015 a couple of significant cases that we still see an impact today. The Affordable Care Act was in fact a tax to require people to buy insurance, and a tax then is constitutional. 14th Amendment, equal protection under the law, is extended to mean that same-sex marriage is constitutionally protected. And that means then if it's protected in one state, you have the Fair Faith and Credit Clause, which would then mean that it's applicable in all states. Admission to a public university. Can that public university consider race as part of its admission criteria? It's very important always to emphasize that we're not talking about qualified versus unqualified applicants. We're talking about qualified applicants, and then to seek some additional explanation as to why one individual is picked over another. And could that reason be that one person is of a race that is underrepresented at a university? And the courts at that time concluded, yes, that's constitutionally protected. This is the current membership of the Supreme Court. We have this list also in Chapter 15, so you can turn to that list there in your text if you'd like, but here we have that list as well. And we can see here that one of the interesting ways of looking at this is the importance of seniority. So at the very top you have the most senior member of the Supreme Court on down to the most junior member. It's not based on age but length of service. You also see here that the Chief Justice is not the most senior member of the court, and that does not have to be that case. In fact, the Chief Justice could be the most junior member of the court, depending on when that position is open and the President's able to make a pick and get that choice supported by the Senate. So when you look at the power of the Chief Justice, a key part of that deals with assigning the opinion of the court, who will write the opinion of the court. This is determined in part if the Chief Justice is with the majority, then the Chief would have that ability. If the Chief is not part of the majority, then it's the senior justice in the majority that is able to make that decision. So there we can see that seniority does have an impact on making this determination. The opinion of the court becomes an important part of the overall power of the court, because how that opinion is written and how it's interpreted will be a key way in which we see the use of the court's abilities and the court's power. So there could be a strategy in which the opinion written in a way that might mean that the interpretation is not very effective. And so, or you could have an opinion of the court that's written in a way that's very specific on what needs to be done. And of course, as we can imagine, the stronger and clearer the opinion, the more likely it's going to be followed. But there are opportunities to write dissenting opinions, so those justices who are not part of the majority can still write a dissenting opinion. This is Thurgood Marshall. He was the first African American on the Supreme Court. He consistently would write dissenting opinions on the issue of the death penalty, even though that there were a majority of people throughout his tenure on the court. This is from the late 60s to the early 80s. Throughout that time, there was a fairly consistent majority for the death penalty, but he was opposed to it and would continue to write dissenting opinions. it didn't change the opinions of people on the court, but perhaps it will change other people's opinions later on and have an impact on future court decisions by having other justices turn to the opinions that he would have written on this issue. May also have an opinion where there's just really no majority. If you have 9 people on the court, you can imagine if you have an opinion that's 3-3-3 in some way, how it would break down in such odd configuration. And needless to say, if you have something like that, then it's going to be a case in which the public and lawmakers have no real sense of what the court is wanting out of that case, and it would be a way of the court just throwing its hands up and not really deciding on a case. We've got to imagine that in most situations they're not going to turn this direction to have a plurality opinion and no majority. These are cases that go directly to the court. Now, roughly as you read through this text, you'll see that there are thousands of cases each year that are appealed to the court. There's roughly about 100 that will be heard by the court, the Supreme Court. And of those 100, about 2 or so, on average, would fit into the category of original jurisdiction, meaning that these are cases that go directly to the court, to the Supreme Court. So they don't go to any other level of the court, and they are to be decided by the Supreme Court. Now, the Supreme Court may remand the case to some other lower court, but in most instances they're going to just review the case because they get very few of these per year. And in fact, if you look at the categories here of cases that are supposed to go directly to the court, I do not believe that there has ever been a case involving number 3. This is in the Constitution, of cases that would go to the court. Generally then, you do have cases, certainly. Think about water rights, especially out west. Perhaps, some water issue between New Mexico and Colorado, where the water is, where the border might fit. We can imagine that perhaps something like that might happen between Oklahoma and Texas on the Red River. Then that would certainly be something that would fit into original jurisdiction and would be under number 2 there, as you can see. But very few cases per year really are under this qualification. So most of the cases then are appellate jurisdiction. Someone has lost a case and they're asking the higher court to review the proceedings. We can understand that if somebody has won the case, there's no reason to ask for a higher court to review it. So it's going to be the lower court or the loser of a case that will ask a higher court to review those proceedings. That's the appeal. And what we've covered throughout this semester, what would be the basis of those appeals? The 14th Amendment comes back a great deal, equal protection under the law, that people have been denied due process. We've certainly covered that a great deal. So looking at the competence of the defense attorney, the ability of the judge, the fairness of the jury, the ability to present a case, all those issues can be brought out on whether or not there was a violation of due process. If roughly 4,000 cases a year are appealed to the Supreme Court, and that comes back to what we were covering in the very beginning of the chapter and the use of the court system. So there are thousands of cases which really have no basis of getting to the Supreme Court, and yet there are appeals. And there's only about 100 then that are going to be listened to and reviewed. We have to then consider that those 100 must be extraordinary. And so there are some repeatable situations or explanations that can have a way for fitting in those particular court cases. And here we have the 4 that we can see of reasons for the Supreme Court to hear a case. Certainly a constitutional issue that's never been resolved. That's a major one. It just fits in terms of the ripeness of an issue that needs to be reviewed. Number 2, clearly if you have 2 lower courts that haven't decided the case or have differences on similar cases, And then you can see here it's an important national issue. Perhaps it's involving the president, for example. So a ripe case, campaign finance laws, we covered that when we were looking at chapter 10, for example. And then gun control, and we looked at this in chapter 4 in our class, in the text, the Second Amendment. So you had a situation here where a resident of Chicago sued that his constitutional rights were denied based on the city laws that would allow only rifles and shotguns within the city limits. Handguns were to be banned. And he argued that because of his age and his limited strength at that point, that he really couldn't use a shotgun, but he could still control a handgun and wanted to be able to still have a handgun. Court reviewed the case and concluded that the Second Amendment, the right to bear arms, meant that a person had the right to have a handgun. So that was a ripe case. It was like a tomato on a vine, that it was of that particular texture that now needed to be plucked. And the same thing there for similar issue for a court case. So there were two lower courts that were looking at this issue here in cell phones. We know just how prevalent cell phones are in our lives today. And so what people might put on a cell phone or what they're using the cell phone for can reveal a great deal about that individual. And so here you have a situation where law enforcement would want to be able to review someone's cell phone. The question then would be, do you have the is there a requirement on the part of law enforcement to have a search warrant? And so you had two conflicting lower courts deciding this case, and the Supreme Court concluded in this case here that yes, you did need the law enforcement needed a search warrant to search a person's cell phone. Two cases involving presidents would certainly fit into this area of compelling national issue. So as referenced in this chapter and then also in chapter 13 with President Nixon, when tapes were required to be released by an 8-0 decision in the court also did conclude that presidents in fact do have executive privilege. They did agree on that. It was really one of the first cases of the courts making that conclusion. This is not specifically mentioned in the Constitution. It's implied, and so therefore now there becomes this way of reviewing, is there in fact executive privilege? And the courts reasoned that yes, a president does have executive privilege. However, a president does not have the right in the use of executive privilege to discuss with his advisors how to circumvent or break the law. So that becomes the tipping point on the issue of executive privilege. And there was also a conclusion that a president can be sued while in office. We can see that with President Clinton in 1998. So this is the process that an individual would go through in the appellate jurisdiction to get a case heard by the courts. And so here we can also see the importance of having law clerks, because they're the individuals who are going to primarily review these appeals. And then they would mention it to their bosses, the Supreme Court justices, whether or not a case is worthwhile to be heard. You do see here that individuals do have the right to appeal without legal assistance, and that's writ of pauperis. So Latin is a language that should not really be evolving, since there's no place where you see Latin used in everyday usage. And as a result then, the way that these phrases and words are used now should continue to be the same way. So that's a reason for using Latin in the law, and would then prevent the possibility, or should limit the possibility, of seeing changes in the application of these terms. And that brings in another Latin term, as we see there, writ of certiorari, where the higher court is commanding an inferior court to turn over court records. The basis of the power of the court comes back here from Marbury v. Madison. We brought this case out when we were covering Chapter 2. You can read about it again on page 604. But it becomes, in many ways, a tradition that it is the courts, the Supreme Court, that has the ultimate interpretation of the Constitution. And so this became the basis of the power of the court and its relationship with the other two branches of government. Without Marbury v. Madison and judicial review, the ability to determine the constitutionality of a law, you really would not have a situation where the court would have the ability to balance out power with the other two branches. In some other Latin terms, there has been a tradition in the court to by and large stand by that which has been decided, stare decisis. So the importance of precedent, the reluctance to overturn past court decisions. And then finally, we look at this issue of what is the basis of being a judge. And are they there just to interpret the law? Are they in some ways there to, based on their interpretations, create the law and create the way the law should be applied? And perhaps sometimes, while there may be criticisms about judges doing that, because after all, they're not elected officials in most cases, the judges may come back and say, but the way the law was written, there was no effective way to know how it should be applied. And so perhaps sometimes judges become activists based upon the status of the law. And they may also become activists simply to try to repair, in their judgment, the direction of where a law is going. So how someone interprets the activities of a judge on whether they are active or restrainist in many ways comes back to how that individual views the purpose of that law to begin with. So like many areas when it comes to the Constitution, and certainly this branch of government that interprets the Constitution, the opinions and the use of those opinions is very personal to each one of us as citizens, and how we then view the conclusions that judges may reach on particular cases. A lot to say about the Supreme Court, a lot to cover here in all 15 of these chapters. So we are concluding here, and again, we'll be having our comprehensive final, and I'll be sending out emails that will give you more information on how to prepare for that in terms of just how to study, but more importantly, how to take this final. So enjoyed the semester. It's gone by, like all these semesters, pretty quickly, and appreciate the work that many of you are putting in here, and that will help you tremendously in your academic career in the years to come. So take care. Thank you for taking this class, and continue to study hard to finish up strongly for this semester.